Welcome in today's talk on jurisprudence. I am Dr. Simranjeet Kaur Gill, Professor in Laws, City University, Ludhiana. Today we shall talk about analytical positivism, its features. So, in introductory remarks, analytical positivism is based on the legal maxim ubi civitas ubi lex, which means significance. Where there is a state, there will not be anarchy, and therefore, the underlying principle of this school is the relation of the law with that of a state. The essential concept of the analytical school of jurisprudence is to deal with the law as it already exists. Law, according to the analytical school, is the sovereign's direction. As a result, analytical schools are also known as imperative schools. In the 19th century, the analytical school rose to the prominence. It claims that morals are not objective, but the law must be objective. If morals are included in the concept of law, the law will no longer be objective. The analytical school take positive perspective on societal legal issues. The positivist main concern is the law that is actually found, positive, rather than the ideal law. Put simply, ideal law is the perfect law for a society or a circumstances where law which is actually found concerns logical and welfare thinking in the legislation. Legislations, court precedents and customary laws are the most important legal sources. This school, which is the most popular in England, establishes the fundamental elements that make up the fabric of law, such as state, sovereignty and the administration of justice. While Bentham, Holland, Austin, Salmon and major components of this school, Austin is considered as a father of the analytical school. The present article reflects on essential aspects related to the analytical school of jurisprudence. Positivism in the law. The positivist movement began at the turn of the 19th century. According to Professor Dias, it was a reaction to a priori thought which turned away from the reality of the actual law in an attempt to uncover the universal validity principle in nature or reason. These ideas were used to explain or condemn actual legislation. Professor Hart had previously said that the term positivism had a wide range of connotations. One interpretation is that laws are orders. The founders of the British positivism, Bentham and Austin, are connected with this notion. Judges do make laws and positivists do not reject this. In fact, the vast majority of them confess it. The term positivism was invented by a French thinker, Auguste Comte. An insight about the analytical school of jurisprudence. Various names have been attached to the analytical school. It is known as the positive school because its adherents are unconcerned about the history or future of law. But as it currently exists, the analytical school was dominant in England and therefore also came to be known as the English school. It is known as the Austenian school because it was founded by John Austin. This school takes the evolved legal system for granted and continues logically to analyze and classify its key principles in order to reveal their interrelationships. Analytical jurisprudence is the name given to this school because of its focus on methodical investigations of the legal principles. Analytical jurist initially interest is to comprehend the structural character of a legal system, and discussions about the justice are not only unnecessary, but also dangerously confusing for the same. This approach to law is termed analytical, and such writers are styled as analytical positivists. So, let us discuss about the features of the analytical school of jurisprudence. Analytical positivism is the separation of law and morality. This means that analytical positivists believe that law can be valid even if it is unjust or immoral. For example, a law that requires people to pay taxes even if they disagree with how the tax money is spent would be considered a valid law under analytical positivism. Analytical positivism is the idea law is a system of the rules that are created and enforced by the state. This means that analytical positivists do not recognize customary law or religious law as a valid law. Analytical positivists are primarily concerned with the study of positive law, which is the law that is actually in force, as opposed to the natural law, which is a system of law that is based on moral principles. Analytical positivism has been highly influential school of thought in jurisprudence since it first emerged in the early 19th century. Some of the most famous analytical positivists include George Austin, H.L.A. Hart and Hans Kelsen. The law is a set of rules. Analytical positivists define law as a set of rules that are created and enforced by the human beings. These rules can be written and unwritten, formal or informal. The law is distinct from morality. Analytical positivists argue that law is separate from morality and that the question of what the law is should not be confused with the question of what the law ought to be. The law is enforceable by the state. Analytical positivists argue that law is enforceable by the state, which has the power to punish those who violates the law. Law is a social construct distinct from morality and religion. Law is based on the authority of the sovereign. Law is coercive, meaning that is backed by the threat of punishment. Law is closed system of rules, and moral considerations are irrelevant to its validity. Law is objective and can be studied scientifically. Now, let us discuss analytical positivism is a school of thought. In jurisprudence, that holds that law is a set of rules that are created and enforced by the state, and that the law is distinct from morality. Analytical positivists argue that law is what it is rather than what it ought to be, and the law should be studied and analyzed in a scientific and objective manner. Analytical positivism was developed in 19th century by jurists such as Jeremy Bentham and John Austin. Bentham argued that law should be evaluated based on its utility or its ability to maximize pleasure and minimize pain. Austin, on the other hand, defined law as a command from the sovereign backed by the threat of the sanction. Analytical positivism has been criticized for its emphasis on state power and its separation of law from morality. However, it remains an influential school of thought in jurisprudence, and its concepts such as distinction between law and morality are widely accepted by the legal scholars. Law is a set of rules created and enforced by the state. This means that state is the ultimate source of law, and that only rules that are created or recognized by the state can be considered law. Some of the most prominent analytical positivists in jurisprudence include Jeremy Bentham, John Austin, H. L. Hart, Hans Kelsen, and Ronald Dworkin. Analytical positivism has had a significant impact on the development of the legal theory and practice. It has helped to clarify the nature of the law and its relationship to other social phenomena, such as morality and politics. Analytical positivism has also been influential in the development of legal education and legal research. However, it is important to note that analytical positivism is not the only school of thought in jurisprudence. There are many other schools of thought such as natural law theory, legal realism, and critical legal studies that offer different perspectives on the nature and purpose of laws. Examples of analytical positivist research: a study of relationship between poverty and crime rates using data from national survey, an experiment to test the effectiveness of a new drug treatment for a depression, a statistical analysis of the factors that influence educational achievement. The key tenets of the analytical positivism: law is a human made system of rules. Law is distinct from morality and other social norms. Law is based on the authority of the state. Law is a system of rules that are created and enforced by the state. Law can be valid even if it is unjust or immoral. So, now let us discuss the purpose of analytical school of jurisprudence. The main objective of the analytical school of jurisprudence is to examine and understand that law as it currently exists in its present form. In this school of thought, law is seen as the direction given by the sovereign authority. It differs from priori approach and aims to study the actual principles of law within the legal system. The analytical school also seeks to define the relationship between law and the state. Founder and advocates of the analytical school of jurisprudence. Bentham, from the year 1742 to 1832, Austin Sir William 1829 to 1914, Sheldon Amanus 1835 to 1886, Holland 1835 to 1926, Salmon, very important person, 1862 to 1924, and Professor H.L.A. Hart 1907 are some of the notable figures who played significant roles in advancing the analytical or positivist school of thought in England. In the United States, Gray and Hoffet also contributed to the analytical school of law, while in continental Europe, proponents like Kelson, Korkunov, among others, lent their support to its development. If we talk about Bentham, Bentham always advocates for the analytical school of jurisprudence, where sovereignty and command played central roles. He recognized the contrast between what society desired and what was logical necessary. Bentham also acknowledged the concept of divided and the partial sovereignty while discussing the legal limitation that a sovereign authorities might encounter. Unlike Austin, Bentham's theory placed less emphasis on sanctions. He believed that sovereign's decree would constitute a law even if supported solely by religious or moral consequences. Bentham's perspective also acknowledged the use of attractive incentives and the idea of reward in his theory. John Austin, an English lawyer from 1719 to 1859, simplified Bentham's philosophy of law and significantly influenced legal thought in the 20th century. Bentham also critiqued the common law system, which was often seen as the exclusive realm of a legal professionals like lawyers and judges, who used complex and technical language to obscure the law from the understanding of the ordinary citizens. This, in Bentham's view, perpetuated a myth. He believed that lawyers were expert in artificial reason, a concept originally proposed by Coke. Bentham differentiated between expositorial jurisprudence, what the law is, and censorial jurisprudence, what the law should be. His definition of the law was that it constituted an assembly of signals, a formation of intentions conceived or chosen by a sovereign in a state. While he supported the idea of laissez-faire in economics, minimal government intervention in economic activities, he advocates for utilitarianism, which meant that the primary purpose of legislation should be to promote the greatest happiness for the greatest number of people. Bentham defined utility as the tendency of something to prevent pain or procure pleasure. According to him, legislation should aim to provide sustenance, generate abundance, ensure equality and preserve security. However, Bentham's hedonistic doctrine, which evaluated laws based on pleasure and pain, has faced criticism, with some arguing that pleasure and suffering alone cannot be the ultimate measure of a law's suitability. John Austin served as a lecturer at the University of London and developed an analytical approach to law, emphasizing the rigorous examination and discovering of the underlying principle of law. His focus was primarily on positive law, also known as just positivism, which is defined as law simply and strictly so called law set by the political superior to political inferiors. Consequently, he joined the term analytical and positivism to describe his school of thought, leading to its designation analytical positivism. Austin is often regarded as the founder of the analytical school, and his lectures were published under the title "The Province of Jurisprudence Determined," are very important in the legal regimes. So, Austin's definition of law was as follows: a rule laid down for the guidance of an intelligent being by an intelligent being. Having power over him, he categorized proper law into three types: God's law, human law and positive law. He also identified two types of improperly named laws and laws by analogy and laws by metaphor. Austin explained that positive morality included laws not imposed by individuals in position of a particular authority or in pursuit of legal spirit. Law imposed by analogy, such as fashion laws, also fell into this category. Importantly, Austin notes that improper laws were not sanctioned by the state. According to Austin, every law, properly speaking, must consist of three elements: command, sanction and sovereign authority. He asserts that law is mandate of a sovereign, ordering his subject to do or refrain from specific action, with an implied threat of punishment for non-compliance. A command represents the wish of a specific individual or group that another person follows specific instructions with the threat of sanction, punishment in case of disobedience. Commands can be specific, directed at individuals or group, or universal, issued to the entire community and applicable to the classes of action and abstentions. Often referred to as a continuance order, Austin believed that the foundation of sovereignty was the habitual obedience to a particular human. Superiors who was not accustomed to obeying a similar superior sovereignty was characterized by unrestricted and indivisible power, with no legal constraints or limitations and no separation of powers. Austin's conception of jurisprudence focused on the legal system of civilized nation as the legitimate subject matter. This was because only in such societies could be sovereign effectively enforce their orders through an efficient administrative apparatus. Austin did not consider custom in his definition. He recognized three types of law that could be exception to his command based definition and fall within the scope of jurisprudence: declaratory or explanatory laws, laws of repeal and laws of imperfect obligations, law without sanctions. Constitutional law, in Austin's view, derived its authority from public opinion regarding its expediency and morality. So, now let us discuss the purpose of the analytical school of jurisprudence. The purpose of analytical school's jurisprudence is to examine the foundational principles of law without regard to their historical origins, evaluations, ethical importance or validity. According to Salmond, a book of analytical jurisprudence will lead with an analysis of the concept of law, an examination of relationship between civil law and other forms of law, as analysis of the various constituents, ideas of which the complex idea of law is made up, such as state, sovereignty and administration of justice, an account of the legal sources from which law proceeds, as well as an investigation of the theory of the legislation and so on. Function of the analytical school of the jurisprudence. Analytical school's fundamental objective is to provide legal principles in a clear and methodical manner, is relevant to a larger and more developed legal system. It begins with the real facts of law as they exist now. It tries to define those words, explain their meanings and illustrates how they are related to one and another. One of the goals of the analytical school is to have a thorough knowledge of the underlying notions that underpin all legal thinkings. Significance of the analytical school of jurisprudence. Analytical jurisprudence significance turns from the fact that it provided clarity to legal reasoning. It gave us a vocabulary that was clear, precise and scientific. It accomplished Austin's goal of clearing the heads and unifying the knots. It purposefully left out all external elements that are not covered by the law. In concluding remarks, the analytical school of jurisprudence is a prominent approach in the legal philosophy that seeks to understand and analyze law by focusing on its internal logic, structure and language. It emphasizes a rigorous examination of legal concepts and principles, aiming to provide clear and objective interpretation of legal rules. Proponents of this school, such as John Austin, H. L. Hart, distinguish between law as it is and law as it ought to be. Prioritizing the former, they contended that law is a product of a human will created by the political authorities and that it should be studied as a factual phenomenon rather than a moral or normative one. The analytical school of law has had a significant influence on the development of the legal theory, particularly in common law jurisdiction, shaping discussions about the nature and the functions of law within the societies. So, analytical positivism is a complex and sophisticated philosophical movement that has had a profound impact on the study of law. So, it is very important to understand the key feature of the analytical positivism as well as its criticism in order to appreciate its contribution to the jurisprudence. Despite these criticisms, analytical positivism remains one of the most influential schools of thought in jurisprudence. Analytical positivism has also been criticized for its emphasis on the coercive nature of law and for its neglect of the role of morality in law. Critics argue that analytical positivism fails to account for the fact that law is often used to promote justice and social welfare. They also argue that analytical positivism is too rigid and that is cannot account for the complexity of the modern legal system. It has been particularly influenced in the development of the common law system. In spite of its critiques, analytical positivism remains an important school of thoughts in jurisprudence. It continues to provide a valuable framework for the studying and understanding the law. So, this was all about today's talk. Thank you for watching this program.